Good day, Crime Talk aficionados. It is Thursday, and we have another great show for you today. First, Nick Reiner sits in isolation there at the Los Angeles jail, and only one visitor. Who could it be? Prosecutors allege the accused Gilgo Beach serial killer used burner phones and was, tracking the cops' progress. An Arkansas man accused of killing an alleged child abuser wins his Republican primary to be the next sheriff. A federal jury orders an influencer to pay $10 million for some defamatory accusations in the University of Idaho murders. I totally agree with that one. And guess what? Britney Spears, she's arrested. We've got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Make sure you hit that little bell. And remember, you can check us out on any of your favorite podcasting apps. Let me also remind you, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do a background search. The results are sent to you while you wait. You're going to get information regarding the individual that you're searching about, cell phone numbers, email addresses, social media presence. You're going to find out if they're married, divorced, do they have bankruptcies, liens, judgments, anything you want to know about them, ladies and gentlemen. It's literally right there. And most importantly, criminal history, and find out if they have to put themselves on one of those sex offender registries. Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for Thursday, March 5th, 2026. And first on the docket, boo-hoo, poor lonely Nick Reiner. That's right. Nick Reiner, the 32-year-old son of filmmaker Rob Reiner and producer Michelle Singer Reiner, has received visits exclusively from his defense attorney while he's being detained at the Twin Tower Correctional Facility as he awaits the trial process related to the charges of his alleged killing of both of his parents while they slept. Like I said, he faces 2 counts of first-degree murder in connection with the December 2025 deaths of his father, Rob Reiner, who was 78, and his mother, who was 70, Michelle. The couple was discovered in their Brentwood residence suffering multiple sharp force injuries. That's code for stabbed to death, ladies and gentlemen. Anyway, the Los Angeles County Medical Examiner's Office ruled both deaths homicide, which seems pretty obvious, probably not a suicide. Doesn't sound like an accident. Doesn't sound like, it just was a miraculous burst of, sharp, blunt trauma injuries. No, it was a homicide by stabbing, and homicides are classified as the killing of one person by another. Anyway, Mr. Reiner was arrested shortly thereafter, and he's been held in custody without bail. Now, during his arraignment on February 23rd, Reiner entered a not guilty plea, and he was represented by the public defender, Kimberly Green, who assumed responsibility after the prior attorney, Alan Jackson, withdrew for no money. Anyway, court records indicate that Green is the sole visitor Reiner has received at the facility. Neither one of his siblings, Romy or Jake, have visited him or attended any of the court proceedings. Now, some people would be shocked. Why would your family members not go? Well, maybe it's because he's accused of killing their parents and they believe that he killed the parents. So why would they go talk with him? And even if they did, it's not like they're going to talk about the facts of the case because they would go tell the prosecutor everything that they heard, right? It's probably best, since they're witnesses in the case, not to go talk with him. So, obviously, given the high-profile nature of the case, Reiner has been placed in administrative segregation at the downtown facility. Now, a former sheriff that worked there stated that such protocols are standard in prominent cases to protect inmates from potential harm by other inmates in general population. Additionally, Reiner is also housed in the mental observation unit, as evidenced by his wearing of a specialized anti-suicide gown during the court appearance. Now, inmates in this classification undergo mandatory welfare checks at least every 15 minutes around the clock and may be kept separate even from other segregated inmates if they deem to pose a risk to themselves or others. Now, Reiner has a documented history of schizophrenia and prior challenges with substance abuse that included multiple periods in rehab. Now, the Twin Towers Correctional Facility, which previously housed other notable detainees, has obviously come under some scrutiny. In September of 2025, the Attorney General Rob Bonta filed a lawsuit against county authorities alleging inhumane treatment and inadequate facilities. In response, the Los Angeles Sheriff's Department have allocated $309 million towards staffing, more deputies, infrastructure repairs, and other improvements of the building. Now, Reiner's next scheduled court appearance is set for April 29th. A conviction on the charge obviously could lead to a life sentence. So, I know this is, everybody makes this out to be big news, but, sometimes the SHU, the Special Housing Unit segregation, obviously there's reasons for that. If you have inmates that can't play well with others, they go to the SHU and they only get out once a day. If they can't be nice to the correctional staff, they go there and get out once a day. They're supervised. And it really sucks for the attorney. Because literally when you're in the SHU, there's usually when you meet with your client, there's bars, but there's usually plexiglass up and you can't pass anything through. Most of the discovery is on computer these days, so it's almost nearly impossible to go over the discovery with your client. Literally, it's about the size of this table here at the Crime Talk studios. And usually have one chair, maybe two, but it's very difficult if you have another individual on your side. And like I said, it's obviously separated. The most important thing that clients complain about when they're in protective custody of the SHU is obviously the isolation. If you're in general population, you get to watch TV. Really, all you can do while you're in custody in the SHU is read books. And it really affects some people. I was actually at the Federal Detention Center today visiting a client, and I saw an attorney. We were, let's just say, we both had a mutual client at one point, and our mutual client had to go to the SHU. And apparently after about a month in the SHU, for lack of a better term, it broke him. And he decided that it's his best interest to ultimately take the deal in the particular case. So the SHU can have some negative effects as well. I wouldn't want to do it. I would go totally stir crazy, maybe read a lot of books. Maybe I'd like it for a little while, but it'd be like going on a vacation more than about 3 days. I'd go totally stir crazy and would want to come back to work. So it's not pleasant. I don't really wish it upon anybody, really. It's not a pleasant experience. People in the SHU, they don't like it, but it's part of the harassment package. Let's just put it that way. Next, prosecutors allege the Gilgo Beach serial killer, let's just say he was tracking them as well. So the Suffolk County prosecutors have disclosed some new details about the digital activity of Rex Heuermann, the 63-year-old architect charged with 7 murders linked to the Gilgo Beach serial killings, and describing patterns they say demonstrate his use of false identities and prepaid devices to engage with sex workers while simultaneously monitoring the investigation into the crimes. So in some court motions submitted this week, prosecutors outlined the evidence from multiple mobile phones recovered from Mr. Heuermann following his arrest back in July of 2023. The documents state that he employed aliases, including one by the name of Andrew Roberts and Thomas Hawk, along with a Tinder account under a fictitious name to initiate contact with sex workers more than 500 times between 2021 and 2023. Now, one device seized at the time of his arrest was used to reach at least 56 sex workers and to contact massage parlors more than 300 times from January 2021 through March of 2022, according to these pleadings. Now, a second phone, active until February of 2023, recorded more than 220 calls or messages to 61 numbers associated with prostitution services. Prosecutors note that both devices were routinely kept in proximity to the phone registered in Heuermann's own name. Now, the motion further described internet searches conducted on Heuermann's phone and a linked Gmail account that included queries such as, quote, why hasn't the Long Island serial killer been caught, end quote, map of all known serial killers, end quote, cops launch Gilgo Beach homicide investigation task force, that was another search, and more than 100 other searches related directly to the Gilgo Beach case were documented alongside thousands of queries involving pornography that prosecutors characterized as focused on themes of violence, restraint, and physical suffering. Now, Heuermann faces second-degree murder charges in the death of 7 women whose remains were discovered along a roadway near the Gilgo Beach between 1993 and 2010. The victims identified in the filings were Maureen Brainerd Barnes, Megan Waterman, Melissa Bartholomew, Amber Costello, Valerie Mack, Jessica Taylor, Sandra Castillo, and most had been working as experts during that time. Now, Heuermann was taken into custody after a 10-month surveillance operation, and investigators obtained his DNA from a pizza box he discarded outside his architectural office. That sample matched genetic material recovered from a burlap wrapping used to conceal one victim's remains. Now, he has pled not guilty to all the charges and remains in custody pending charges. The new filings by the prosecutor was in response to the defense motion seeking to exclude certain evidence, including arguments that privacy laws were violated when the police collected the discarded DNA sample, and that the one count involving victim Sandra Castillo relies on overstated facts. Now, prosecutors maintain that the DNA match was independently verified through a court-authorized swab, and that the digital evidence is admissible. Records also indicate prosecutors have identified more than 150 potential witnesses, including civilians, law enforcement personnel, and expert witnesses. The defense has not yet provided its own discovery materials, prompting prosecutors to request that the court compel compliance with the court's orders. Now, Heuermann is scheduled to appear once again in court on March 17th. Now, sometimes you have to be careful when you file motions. When you bring up the fact, hey, you've seized all this evidence, it should not be obtained, or you file a motion to eliminate trying to exclude particular evidence, then it all comes out, so to speak. Now, what does a search in 2021 through 2023 have to do with cases that go back 10 years older? That the fact that the guy goes to massage parlors and apparently goes and sees prostitutes. How is that not propensity evidence? I don't see how it's relevant unless he got up and testified and said, I've never been to a prostitute. I don't even know what a sex worker is, right? Then that could come in for impeachment purposes. But it's 404B evidence, propensity evidence. Now, I've said this before and I'll say it again. If prosecutors need to rely upon 404B evidence, it usually means their case is weak, or they think that they have weaknesses. So they throw in and they sprinkle in a little propensity evidence that completely goes against the rules, saying that Mr. Heuermann should be tried on these charges and these charges alone, and not every other bad thing he's ever done in his life. Think about it, ladies and gentlemen. If you were charged even with a simple speeding ticket and the prosecutor wanted to bring in the fact that you were sent to detention in the 6th grade, you say, what the hell relevance is that? Or they bring in the fact that you have a phone and you had some searches on it that were, to sites that maybe you're a little embarrassed about. You say, why is that relevant to this charge? It isn't. But the prosecutors are going to come up with some reason to try to articulate why it is, and the judge will more than likely go along with it. And then when cases go up on appeal, why do they mostly come back? Obviously, errors in the instructions and 404B evidence. The courts are tired of 404B evidence. Prove your case with what you've got. Now, let me also remind you that Mr. Heuermann, who resided in the Massapequa Park with his wife and children while commuting to work in Manhattan, was charged after DNA evidence connected him to the case that remained unsolved for more than a decade. And the prosecutor's filings emphasized that the phone activity continued along with the initial discoveries of the victim's remains. 404B evidence. Next, how about a little tears flowing in the Kouri Richis trial? That's right. In the highly charged moment during the ongoing murder trial of Kouri Richis, her reported romantic partner broke down sobbing on the witness stand as jurors reviewed private text messages exchanged in the weeks leading up to the death of her husband, Eric Richis. Now, Robert Josh Grossman, a 43-year-old handyman and Iraq War veteran, provided testimony on Wednesday detailing his communications with Richis, the mother of 3 who faces charges of first-degree murder. Now, prosecutors allege that Richis deliberately laced a Moscow Mule cocktail with 4 times the lethal dose of fentanyl, resulting in her husband's death in March of 2022. Now, court records presented during Grossman's appearance showed messages in which Richis inquired whether Grossman would marry her immediately if she were divorced. He replied affirmatively, writing, "Yes, in love with you. Of course I would." Days later, Richis reportedly texted, "If he could just go away and you could just be here, life would be so perfect." Grossman visibly struggled to maintain composure as the exchanges were displayed and at one point was wiping his eyes on the stand. Now, Grossman further recounted a conversation that occurred shortly after Eric Richis' death. During that exchange, Richis asked whether he had ever killed anyone while serving in Iraq and inquired about the emotional impact of such an experience. Grossman confirmed he had taken a life in combat and described the discussion as unusually heavy and candid. He stated that at the time he harbored no suspicion that Richis was involved in her husband's death. Well, following Eric Richis' passing, Kouri Richis self-published a children's book addressing grief, which she said was intended to support her son and other young readers dealing with the loss of a parent. Prosecutors maintain that the evidence demonstrates Richis orchestrated the killing to gain control of her husband's estate, valued in excess of $4 million, and to pursue a new relationship with Mr. Grossman. The prosecutors told the jury early in the proceedings in opening that the evidence will prove that Kouri Richis murdered Eric for his money and to get a fresh start at life. Now, Richis' legal team has countered that Eric Richis died from an accidental overdose and that the death was not a homicide. The author has pled not guilty to all the charges. The trial continues, and we are bringing it to you live, gavel-to-gavel coverage here on Crime Talk, so go check it out. It's actually pretty good entertainment. The attorneys, I'm not going to lie, not the best. But, listen, you got a dead spouse, a love triangle, and money. Who doesn't love watching this stuff, right? Who doesn't? Go check it out. Next, hey, if you are accused of killing somebody that was doing something inappropriate with your daughter and you killed them, what should you do while you're waiting trial? I know, run for sheriff. That's right. A man charged with murder and the shooting death of the individual accused of sexually abusing his 13-year-old daughter has captured the Republican nomination for sheriff in the rural Arkansas county, defeating the incumbent despite remaining out on bond pending his trial. So Aaron Spencer secured more than 53% of the vote in Tuesday's primary election, according to the unofficial results released by the Arkansas Secretary of State. He defeated the Lonoke County Sheriff, John Staley, whose department actually arrested Spencer in connection with the October 2024 incident that resulted in the murder charge. Now, Staley conceded the race in a statement posted on Facebook saying he respected the voters' decision. Well, Spencer, who is awaiting trial on murder charges in the death of Michael Fossler, 67, ran on a platform highlighting what he described as law enforcement's failure to protect families. And Fossler had been released on bond at the time of the shooting after facing multiple charges of sexual offenses, including Spencer's daughter. Now, court records indicate that Spencer awoke to find his daughter missing from her bedroom, searched for her in his truck, and located her in the passenger seat of a vehicle driven by Fossler. Spencer forced the vehicle off the highway, leading to a confrontation during which he shot Fossler. He then contacted 911 to report the incident. Now, prosecutors maintain that Spencer had planned the confrontation in advance and had opportunities to involve law enforcement rather than to take this vigilante action. Spencer has pled not guilty and remains free on bond. His trial, originally scheduled for January, was postponed after the presiding judge was removed from the case, and no new date has been set. Now, Spencer's attorney acknowledged that he fired the fatal shots, but asserts he acted lawfully to protect his child from an immediate threat. Aaron Spencer did exactly what the law allows and exactly what any father would do. He protected his daughter and himself from harm, like I said, according to the defense attorney, and she added that the election outcome has no impact on the legal proceedings. Now, in a statement following the victory, Spencer emphasized themes of accountability. He said, "Tonight, the people of Lono County stood up and chose transparency and accountability. This wasn't a campaign about me. It was about every family who called for help and got nothing. That betrayal ends tonight." Now, if elected, Spencer has pledged to create a dedicated unit within the sheriff's office focused on combating sexual crimes against children. Now, Spencer will now face Democrat Brian Mitchell Sr. in the November general election in the heavily Republican county. The outcome of the murder case will determine whether he is eligible to assume office, because obviously if he's convicted, he's going to prison. And if he's a felon, he can't possess a gun, which is kind of required if you're going to be the elected sheriff. Would you not agree? Yes, I would. Interesting case. I mean, this is really like one of those movies, the book, like A Time to Kill. Somebody's driving away with your 13-year-old daughter. You drive, find her, maybe not sure exactly what's going on, but it doesn't really matter. You kill the guy. I'd say this is kind of like a, self-defense thing. Although there are 3 witnesses, the daughter, the dead guy, and the sheriff, potential sheriff, right? Only 2 are coming to court. I think it's self-defense all over the place. So, or jury nullification. Guys on bond, accused of doing bad things to children, and just coincidentally just happened to pick up another 13-year-old that's like 60-something years old. Let's get for real. Some 60-something-year-old man is not exactly every 13-year-old's fantasy. Let's get for real. And it's just weird and creepy, right? I say prosecutor needs to re-examine this case. And, I think obviously everybody's entitled to a jury trial here, but I think that the people have spoken. I guess we'll find out in November if that's truly the case. Next, a case that, frankly, I'm pleased with, and frankly, I don't know. There should be more of this. A jury has ordered that an influencer has to pay $10 million for making defamatory statements. So a federal jury directed social media influencer Ashley Gilliard to pay the University of Idaho professor Rebecca Schofield $10 million in damages after determining that Gilliard's online statement falsely implicated the professor in the 2022 killing of 4 students. Now, the verdict came down on February 27th, and Gilliard, who produces content analyzing high-profile criminal cases and often incorporates little tarot card readings, posted a series on TikTok videos back in November of 2022. In those, she asserted that Schofield was responsible for the murders and suggested or stated that the professor had engaged in inappropriate romantic relationships with one of the victims. Now, Schofield filed a defamation lawsuit, as rightfully she should have, and court records show that the professor had sent multiple cease and desist letters requesting that Gilliard cease the allegations. The influencer continued to publish videos even after the Moscow Police Department issued a public statement in December of 2022, confirming that Schofield was not a suspect. And then in June of 2024, a federal judge concluded that Gilliard's statements were defamatory. The judge determined that the claims rested exclusively on the influencer's spiritual intuition about the murder and lacked any objective factual foundation. The judge further observed that the post persisted following the police department's clearance of Schofield. So obviously the murders occurred in November of 2022. at the University of Idaho. Brian Koberger later confessed to the crimes and was sentenced to 4 consecutive life sentences. Now, during the trial, testimony addressed the lasting professional harm that can result from unproven online accusations. The jury allocated $6.5 million in damages for the statements linking Schofield to the murders and $3.5 million for the false claims concerning an inappropriate relationship with a student. And in a statement issued after the verdict, Schofield described the decision as a clear affirmation that false online statements carry real-world consequences. And she added that the murder represented a tragic chapter in the university's history and that the victims and their families deserved respect during such events. Anyway, Gilliard addressed the ruling in a 21-part TikTok series posted on March 2nd and 3rd. She maintains that the verdict did not reflect the evidence presented, questioned the impartiality of certain jurors, and indicated that she may pursue an appeal. Well, ma'am, TikTok influencer, tarot card reader, you are why defamation laws need to exist. And frankly, there are so many people out there that think that they can put anything on the internet knowing that it's false, have nothing to back it up with, and they literally ruin people's careers and reputations. I can tell you, we're currently pursuing a case for an influencer who has somebody that puts up false statements, and it has been difficult to say the least. But here, at least this influencer said, yeah, I made those statements and put them up there, right? But a lot of times people make these things anonymously and you have to track them down. And then you find out that the people that have been denying everything the whole time are just flat out not being candid and truthful whatsoever. But it is real. And there needs to be changes in the law to make it easier for people to sue people that make false claims and they have no evidence to back it up. Seriously, like I said, doesn't matter what you believe, doesn't matter what you think, it only matters what you can prove by legal and competent evidence. And frankly, if, these crazy theories that people put out there about some of these cases, I mean, some of them are so ridiculous you can't even repeat them, right? And some people, no matter what it takes, like Brian Koberger pled guilty. And there are still people out there that say, I don't think he did it. Okay, go seek mental health treatment, ladies and gentlemen. Okay, you live in an alternate universe. You do. I hope that you seek health care treatment, mental health care treatment, ladies and gentlemen. Next, an Iowa man arrested in Colorado after a triple homicide in Utah. So this ended down in Pagosa Springs, which is down in the southwestern part of the state, kind of near Durango, Colorado, kind of near the Four Corners. Pagosa Springs, absolutely beautiful area. They get a ton of snowfall every year. Beautiful area. So a 23-year-old man from Iowa has been taken into custody here in Colorado in connection with the deaths of 3 women whose bodies were discovered at separate locations in Wayne County, Utah, according to police. Ivan Miller was apprehended without incident in Pagosa Springs following a multi-state search that began after 2 women were found dead Wednesday afternoon on a hiking trail near Capitol Reef National Park. A 3rd woman was later located deceased inside a residence in the nearby community of Lyman. Investigators believe that the woman was in the home was killed prior to the victims discovered out on the trail. Now, according to the Utah Department of Public Safety, Miller had no known prior relationship with any of the victims, who were all residents of Utah. Now, their identities have not been released pending notification and next of kin. And the 2 women found on the trail were in their 30s and 60s. The victim at the Lyman home was in her 80s. The husband of the trail victims contacted law enforcement to report the discoveries at approximately 4:30 on Wednesday. Police stated that Miller allegedly took a vehicle belonging to one of the trail victims. The vehicle was tracked through southern Utah and northern Arizona before it was located abandoned in Pagosa Springs. A brief search involving drones led to Miller's arrest. He was found in possession of a concealed handgun and a large knife, according to the Pagosa Springs Police Department. Mr. Miller is currently being held in the Archuleta County Detention Center on that weapons charge, and the Utah Department of Public Safety and the Wayne County Sheriff's Office continue to lead the homicide investigation there in Utah. Police have confirmed there is no longer any threat to the public safety and that no additional suspects are being sought. During the search, residents were advised to lock their doors, remain indoors, and obviously remain vigilant. The Wayne County School District canceled classes for Thursday and Friday as a precautionary measure, and counseling services will be available to students when classes resume next week. Crazy. I'm telling you, you go hiking out in the woods, ladies and gentlemen. I don't care if it's a bear or a freaking crazy psycho person. Arm yourself. Arm yourself. I'm telling you. All they're going to do is come throw you in a body bag. You have to be able to take care of yourself. Next, Britney Spears arrested on suspicion of DUI. That's right. Pop singer Britney Spears was taken into custody Wednesday night after the California Highway Patrol pulled her over for suspicion of driving under the influence. The 44-year-old pop artist was stopped around 9:30 p.m. on March 4th in the Westlake Village area after officers observed her vehicle exhibiting erratic driving behavior. She was alone in the vehicle at the time of the stop. Following the arrest, Spears was transported to the hospital for evaluation before being booked into the Ventura County Jail shortly after 3 a.m. She was released several hours later, around 6 a.m., under a cite and release procedure. Her vehicle was towed from the scene. Now, a representative from Spears issued a statement Thursday morning describing the incident as unfortunate and completely inexcusable, saying that Britney is going to take the right steps to comply with the law, and hopefully this can be the first step in an overdue change that needs to occur in Britney's life. Hopefully she can get the help and support that she needs during this difficult time. Anyway, court records show that she's scheduled to appear in court there in Ventura County on May 4th. The official booking records available shortly after the arrest did not publicly specify this precise charge, though the law enforcement sources confirmed the detention was related to the suspicion of driving under the influence. Now, the California Highway Patrol has not issued further comment on the circumstances of the traffic stop, and, well, who would they? Why would they? It doesn't matter. It's just another stop to them. But sad thing, I mean, if anybody's seen anything on old Britney Spears, you know, she's posting these weird videos dancing. I thought she lived in Las Vegas, but apparently she's in California now. I don't know. Her life is a mess. She doesn't see her kids. I think she may have some issues going on. We'll just leave it at that. Kind of a sad situation indeed. Next, this day in legal history, March 5th, 1770. British soldiers fired into the crowd on King Street in Boston, killing 5 colonists, an event that quickly became central to debates about unlawful authority, the use of force, and the right to a fair trial. The resulting prosecutions with John Adams on the defense team became an enduring rule of law, touchstone in the American legal culture, right? Future president defending the British soldiers? You betcha. That's what defense attorneys do, baby. That's right. Next, the Supreme Court decision in Nebbia v. New York, 1934, a 5-4 ruling. Issued on March 5th, 1934, the U.S. Supreme Court upheld the New York's milk control law, which authorized the state to establish minimum retail prices for milk during the Great Depression. It affirmed that states possess broad authority to regulate private businesses when such regulation serves a legitimate public interest. And it was a significant shift in the constitutional jurisprudence, moving from the restrictive era approach to the economic due process under the 14th Amendment, helping to lay the groundwork for broader governmental intervention during the New Deal, right? Because FDR was one of the worst presidents ever, threatened to stack the court unless he didn't get his policies through. Next, Supreme Court decision in Lynch v. Donnelly, 1984. The court issued a 5-4 decision holding that the inclusion of the nativity scene as part of the larger public Christmas display sponsored by the city of Pawtucket, Rhode Island, did not violate the establishment clause of the First Amendment. The court reasoned that when viewed in context with secular holiday symbols, the display served as a legitimate secular purpose of celebrating the season and did not constitute government endorsement of religion. Next is our legal quote of the day, and it comes in regards to a legal quote from John Adams in defense of the Boston Massacre trial. Now, one of the most notable and enduring legal quotes associated with John Adams, who was representing the British soldiers charged with the Boston Massacre, appears in his closing arguments that were actually delivered on December 3rd and 4th of 1770 before the judge in the court there in Boston. Quote, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence," end quote. Now, in that summation, Adams, like I said, acting as defense counsel, despite some public hostility towards the accused, emphasized the fundamental legal principle that verdicts must rest exclusively on objective evidence and established law rather than emotion, political pressure, or popular sentiment. His defense contributed to the acquittal of 6 soldiers and the reduction of charges to manslaughter for the remaining 2. And then finally, our dumb criminal of the day. Let's go to Watertown, Connecticut. In what can only be described as a triumph of audacity over common sense, 23-year-old Ali Orsini Asani of Naugatuck has been unanimously selected as the recipient of our daily Dumb Criminal of the Day award for an escapade that managed to combine prior warnings, property damage, vehicular theft, and a little bit of dramatic sabotage in one remarkably inefficient afternoon. Now, according to police, Orsini Asani, who has been explicitly instructed to maintain the distance from a residence on Penny Lane, particularly when not adhering to the prescribed medication, allegedly chose February 24th as the ideal moment to disregard that guidance entirely. Witnesses reported a forceful entry through the rear door, followed by an ascent to the upper level where the accused reportedly confronted the occupants of having involved law enforcement in an earlier similar episode. Moments later, he is said to have descended once more, appropriated the keys to the residence for an escape, and departed with the declared intention of relocating to California. Needless to say, the police noted visible damage to the 2 doors of the property, underscoring the thoroughness of the intrusion. The Watertown officers subsequently located the suspect at the Naugatuck Apartments, where his refusal to cooperate necessitated mobilization of additional personnel, including a K-9 unit, detectives, a supervisory staff, and escalation that transformed a straightforward warrant service into a minor tactical operation. The resulting charges from Watertown police include second-degree burglary, larceny of a motor vehicle, second-degree criminal mischief, first-degree criminal trespass, disorderly conduct, criminal violation of a restraining order, engaging in a public pursuit, reckless driving, and operate a motor vehicle with a suspended license. That'll get him. Anyway, the Naugatuck police added a separate count of violation of a protection order, and Orsini Asani is being held on a $100,000 bond. Now, while the route to California proved shorter than anticipated, ending in fact at the booking desk, one must admire the consistency of purpose for transforming a simple directive to stay away into a comprehensive catalog of felonies. Now, Mr. Ali Orsini Asani earns our highest and only accolade of the day. Congratulations, sir. The trophy is metaphorical, but the lessons one's hopes will be retained. Sir, you are a dumb criminal of the day. All right, ladies and gentlemen, that's all we have. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.